Assalamualaikum warahmatullahi wabarakatuh and good morning to everyone. Welcome to my class LGB30603 Business Law. And today's chapter we are going to cover on chapter 6, which is on law of contract, or sometimes it is also called as contract law. And the statute we are going to refer to Contract Act 1957. My name is Madam Ismila binti Ishaq, and our reference for this subtopic or chapter is from Lee Mei Ping, Ivan Journal Data 2009. At the end of the class, or at the end of this chapter, we are going to cover an introduction. You must be able to understand on the introduction, the formation of contract, what are the elements of formation of a contract, and this is very important, the types of contract, discharge of contract, and remedies, and last but not least, the subtitle for this topic is on avoidable contract. For today's video lecture, we are only going to cover an introduction and formation of contract elements only. We will see you again in the next video lecture for another subtopics. Introduction. When we discuss about contract law, contracts are an integral part of our daily life. They live constantly being entered into by individuals, being other individuals with other individuals or businesses, as well as business with other business, to tell or transfer property, to provide and receive services, and other rights and obligations created. How to define what is contract? The word contract may be defined as an agreement enforceable by law. A contract is an agreement which is legally binding between parties. According to Contract Act 1950, Act 136 revised 1974, there are few elements of a contract. The first element are offer, secondly is acceptance, third is capacity, fourth is consideration, fifth is intention to create legal relation, and last but not least is called certainty of a contract. For your information, these elements of a contract are very important. Now let's have a look on the first element, offer. Offer must be distinguished from invitation to trade. Offer can also be explicit. Offer also must be explicit or implied. Offer can be made to the public or specific. And last, offer must be communicated. According to Section 2, bracket A and bracket H, Contract Act 1950, we can define an offer. You can refer to this section for a definition of an offer. And also under this element of offer, there are few cases. And for your information, we are going to focus only on Carlyle versus Carbolic smoke ball cases. Have a look in your textbook. This is the image of Carlyle Carbolic smoke ball cases which I have downloaded from internet. This is the smoke ball. And according to this Carlyle smoke ball case, he offered to the public, whoever still get influenced after consume this carbolic smoke ball, they can get reward of 1,000 pounds sterling. And according to this case, the defendant win the case because he still get affected after he consumed the smoke ball medicine. Second element is called communication of offer. The offer must be communicated to the referee. It can be directed to one person or a group of people, or also to the general public. Without communication, there can be no acceptance to turn an agreement into a binding contract. Refer to R versus Clark case. Offer is different from invitation to trade. Invitation to trade is a situation when one party displays or advertises or exhibits goods or materials in order to introduce offer from another party. It is also called an offer to consider offers and cannot be created an agreement if based on a purported acceptance. So invitation to trades could be from advertisement, display exhibits, tender auction, and also catalog. Next element is on acceptance. According to Contract Act, Section 2, bracket B, you can find the definition of acceptance. Section 7, bracket A, acceptance must be absolute and unqualified. Any modification, variation may be amount to counter offer. So again, for this particular element, we will study deeper from a case of height and range. Okay class, this is the same explanation on acceptance. Acceptance is the different form from counter offer, cross offer and inquiry, must be absolute, clear and unqualified, made according to the manner stated by offer, and must be communicated to the offerer. Acceptance must be communicated. Acceptance must be communicated to the offerer either by words or by conduct. Section 7b. Mental acceptance or silence is insufficient, or we can say that mental acceptance or silence is not accepted in contract law. Refer to case Fraser and Everett. According to section 6b, acceptance must be within reasonable time. This is the name of the case. Acceptance, how about acceptance by post? A general rule, once it is posted, it is effective or binding upon the offerer. Decided in the case of Adams and Lindsay held, acceptance is effective as soon as it is posted. However, according to section 4(2)(a), acceptance is complete against the offerer when it is put in a course of transmission. Next element is on consideration, executed or present, for future and also past consideration. For present consideration, it is known as an act in done for a promise, for example, payment of a reward for an act done. For the future consideration, where parties exchange promises, each promises being for the consideration for the other, or consideration is intended to be performed in the future, for example, sales of goods and payment due upon delivery. And last, under consideration is called past consideration. The promise is made on account of past consideration. Okay class, have a look at this example. Section 26 Contract Act. An agreement without consideration is considered void. Consideration is when both parties must provide some benefit to each other. Bilateral. A. Party A agreed to pay 9,000 for a car sold by B. Party B. B passes the ownership to A. Unilateral. A promised B rewards if he does as A instructed. Upon acting on A's instruction, B was rewarded. If only one party provides consideration, it is a gift. Consideration need to be adequate. Section 26. Okay, you may also refer to section 2D and also section 26A. Okay, on the past consideration is a good consideration. Natural love and affection is valid consideration. Section 26(a). Part payment as consideration, waiver of performance. Section 64 Contract Act. Okay, and also please refer to section 2D Contract Act. The promise, no, or any other person. Okay, intention to create legal relation. Okay, class. Next is on intention to create legal relations. There are two types of agreement: domestic social agreement or business commercial agreement. For the social or domestic agreement, parties do not intend to create legal relation. Onus on a plaintiff to show contract is intended, whereby for the business commercial agreements, parties do intend to create legal relations. Onus on defendant to show a contract was not intended. Marriage, you can also refer to these two cases for the marriage or social agreement, and also for the business contract, you can also refer to this example of case. Next element is on uncertainty of terms. There are two principles in common law. The terms of agreement cannot be vague and must be certain. Contract. Secondly, contract will fail due to the failure to reach agreement on a vital or fundamental terms of an agreement. According to Section 30 Contract Act, an agreement, the meaning of which is not certain or capable of being certain, are void. Refer case Kanupan Chetty versus Swah Tian. Next element is on capacity. Assumptions under common law. The contracting parties must have the capacity to do so. In Malaysia, Section 11 of Contract Act, age of majority according to the law and of sound mind, which means in order for individual to go inside to bind a contract law, the age of majority is at 18 years old and it must be sound mind. Refer to case Mohari Bibi versus Damundas Gus and Tan Hee Tuan versus Tan Boon Kit. Contracts by offence are void, which means you cannot have a contract with people or with anyone which is below age. Exceptions to the rule. Contracts for necessaries and also contracts for scholarship. Refer to Section 69 of Contract Act. If a person is incapable of entering into a contract, it supplied by another person with necessaries suited to his condition of life, the person is entitled to be reimbursed from the property of a such person. Case Nash versus Inkman. Scholarship. Section 4A bracket A of Contract Act. Case from Government of Malaysia versus Charan Singh. Other binding contracts, insurance contract, refer to Insurance Act 1966 and apprenticeship refer to Act Children and Young Person Act 1966. Okay class, that's the end of the class today. We have already covered for the introduction and also the elements of a contract. I'll see you again in the next class for another subtopic for Contract Act. See you again. Thank you.